62B District Court exam session with the Honorable Amanda Sterkenburg presiding.
Good morning, Mr. Stevenson. Thank you for your patience this morning. Can you hear me okay?
Yes, I can, Your Honor. Good morning as well.
All right, the court is calling the case of the State of Michigan versus Arthur Geeter Brown II, case number 21-60057FY. Counsel, your appearances for the record.
Good morning, Your Honor. Nick Sheehan appearing on behalf of the people.
And I do not believe I represent Mr. Brown, Your Honor.
Really? Well, the defender's office is appointed on his matter, and you are the defender that's here.
Well, Mr. Sheehan did not give me a form. It's not in my schedule. I do not have a file, Your Honor, so I'm kind of running blind then. It's news to me.
Well, I guess we've called the case, but we'll go off the record now and try to sort this out.
Sorry about that, Judge.
All right, thank you. All right, Mr. Stevenson, it's not my intention to make you handle a case that's not yours. So we are gonna contact, we think it's Marissa Barkema from your office, and find out where she is this morning.
Well, I can tell you right now, for better or for worse, Ms. Barkema, according to our schedule, is on vacation. Is this a scheduled PE or is it a scheduled PCC?
This is a scheduled motion. I would assume that based on the review of the file, it is to update the court on the status of his competency evaluation.
Okay, I believe that I could probably do that. For the most part, it's been my experience that our office will stipulate to the findings of the Center for Forensic Psychiatry. I will rely on the report.
Mr. Stevenson, I'll stop you right there. We'll go back on the record in the matter of Mr. Brown, file number 21-60057FY. Mr. Sheehan is here on behalf of the state. Mr. Stevenson is stepping in for Ms. Barkema, public defender. The record indicates this matter was scheduled to review this morning for purposes of learning where the competency evaluation was, and I have not received it. So Mr. Brown was ordered to a competency exam back on March 4th of this year. Mr. Sheehan, do you have a copy of it? I think it probably is still pending.
Judge, yes, I do not have a copy of it. I do have some correspondence between our office, prosecutor's office, and the forensic office, the psychiatry office. It does say the evaluation has not been scheduled as of yet, will be scheduled within the next couple of weeks. That email was dated Friday, May 7th. There is a handwritten note from Catherine Kosky from our office saying that she called Jennifer from 62B, Lindsay, to let her know we'll keep on docket for now. There's follow up and find out why it's taking so long. The evaluation will adjourn. I think this is just a situation where here we are, we set this for a forensic and Mr. Brown has not been scheduled or will be scheduled and it's not been seen yet. So I think it's just, as Your Honor pointed out, just a review here.
Okay, well, then we've reviewed it. And the situation is we have nothing to take action on today, Mr. Brown. So thank you, Mr. Sheehan, for updating the court. We'll find out why Ms. Barkema didn't, well, I'll speak with my clerk, but for better or for worse, as you said, Mr. Stevenson, Ms. Barkema isn't here, and we'll just adjourn this to another date to get another update later down the road.
May I ask one question though, Your Honor, and I will pull Ms. Barkema's file and make the appropriate notations, but are we still within the 90-day time frame of the original order?
The original order was March 4th.
March 4th? Okay. Because I was just wondering if we needed to do an addendum or if the order is still in effect, I should say.
Well, it would still be in effect. We'll
Okay.
have to wait and see whether it gets done though within the
I don't mean to laugh, Your Honor, but I understand completely.
Yeah, so, well, do you know when Ms. Barkema is returning?
Yeah, she'll be back in next week, Judge.
All right, maybe you can just bring it to her attention then.
Absolutely, I will make sure I do that. You'll be in contact by our office, Mr. Brown, once Ms. Barkema gets any information from the Forensic Center, okay? And she'll do her best to give you notice of any and all further appointments.
So would it be possible I can get a bond reduction or how that?
Once the competency evaluation comes back, we'll address the probable cause conference, and that is the appropriate time for a bond reduction, in my humble opinion.
All right, thank you, Deputy. We don't need Mr. Brown. All right, Mr. Stevenson, what matter did you intend to be here on today?
Well, I intended to be here on Miss Estes, but unfortunately, I've had no contact with her, and I'm not sure if she's present in the courtroom or if she's by Zoom. I do know that she's on parole. The parole hold was lifted. The contact information I've been given is for somebody completely different than Miss Estes.
Well, she's not in the courtroom, and she does not appear in my Zoom waiting room either.
And I'm not sure, does the court file reflect who her parole officer may be? Because the information that I was provided from court services is not a very in-depth report. It's one of the one-page reports that are typically prepared for parolees. I do note that she's on parole, but I'm not sure who her parole officer might be to try to track her down.
I can look and see what we might have.
It's very difficult calling the Department of Corrections. You get a phone tree in Lansing and then it hangs up on you after about 15 minutes.
No, unfortunately, I don't have any information that indicates who her parole officer is.
Well, I've got some time, Your Honor. I can obviously do some legwork here. Would you be willing to keep this on for the preliminary examination with no witnesses? And if I'm able to contact her, I will contact the court as well. But obviously it's your discretion, Judge.
Sure, the court is calling the case of the state of Michigan versus Chantel Shear Estes, case number 20-60176FY. Counsel, your appearances for the record.
And Brett Stevenson on behalf of Ms. Estes.
This matter is scheduled for a probable cause conference at 8:30 this morning. And Mr. Stevenson, we haven't seen your client. The file indicates that she bonded from the Kent County Jail. information I have says, suggests that you have not had contact with her. That's correct?
That is correct, Your Honor. When we received the file, we did note that she had posted bond. However, there was a hold placed upon her, and I'm 99% sure it was by the Department of Corrections. I noticed when I went to visit, the hold was removed. I called the number provided with court services. It's some gentleman on the east side of the state that's never heard of Miss Estes. She has not responded to our letter sent to her last known address as well as the jail. I have no idea if she's currently incarcerated or if she's quote unquote on the lam.
All right. Well, this matter is set for a probable cause, or I'm sorry, a preliminary examination on May 20th. We will leave it on for that date with no witnesses, so no subpoena should be issued for a prelim, and we'll give you a week to contact your client, Mr. Stevenson.
Yeah, I'll do my best, Judge.
And if she fails to appear on the 20th, then we'll issue a warrant.
Thank you.
You're welcome, and thank you for your patience and your courtesy this morning.
And I will see you at approximately 10:30. I think I have Mr. Lawler. Is that on your schedule for 10:30?
It is.
Okay, well, thank you. I will see you shortly.
Thank you. Mr. Sheehan, I have Defendant Newton present in the courtroom. Have you had any contact with Attorney Blamino this morning?
Let me come in there. I'll be in there just a second, Judge.
Okay. Good morning, everyone.
Good morning.
Mr. Blumenow, I have Mr. Newton present in the courthouse.
Mm-hmm.
He indicates he hasn't had an opportunity to speak with you yet. Shall
We
I
have not.
a breakout room so that you can confer?
If we can figure that out somehow, I'd very much appreciate that. Thank you.
I sure can. What I'm going to do is I'm going to have my bailiff escort Mr. Newton to an office here where we have a laptop set up. He'll be in private quarters, and then we'll place you in a breakout room on the laptop in there so you can have a private conversation.
I appreciate that, Judge. Thank you.
You're welcome. Mr. Blumenow, you should have an invitation. to that breakout room. Did you take him to conference room 4? All right, fantastic. I have someone appearing on my screen as Bear. Could you please identify yourself for the court?
Yes, my name is Kimberly Stoddard. I am Joe Stoddard's mother and guardian. He will be joining us shortly.
Okay. That's your case, Mr. Kuipers, correct?
It is.
Are you going to need a breakout room to speak with him?
We'll see about that. I mean, I guess I don't know the nature of the proceeding. That I don't know what's going on today. I know that he's been arraigned already, had a bond set, and we have a probable cause conference on the 20th in the morning.
And then my clerk called you and told you to be here today?
At about 3 o'clock yesterday, yes.
And she didn't reference why?
I think that she addressed the issue of a bond in the email. Jennifer and I never talked. I did speak with Mr. Sheehan after 5 o'clock yesterday about the case.
All right, well, when your client appears, we'll call the case and decide what we need to do.
He is here now.
I think his mother just said he's there now, Your Honor.
I just muted her, but I think you're right. Is that Mr. Stoddard sitting with her?
Yes, Your Honor. I was in the middle of a shower.
All right, here's what I'm going to do, Mr. Stoddard. I'm going to place you into a breakout room with your attorney so you can discuss this matter. You're before the court today on a bond reduction hearing. So the two of you can discuss that before you come back and call the case.
Okay.
Your Honor, I guess I'd never filed a motion on bond reduction. Obviously, Mr. Stoddard is out.
Mhm.
I did talk to Mr. Sheehan about the facts of the case, which I do not believe any crime occurred here at all. And I believe there's strong evidence to that effect, but he wasn't prepared to discuss it as it was after 5 o'clock and he hadn't read the file or had a chance to speak with Ms. Smith.
Well, here's what I know. Here's what I know. I know that the alleged victim in this matter has contacted the court on a number of occasions. And I indicated to my clerk that if all parties could get here, I would consider a modification of the bond upon argument, because she is been in contact with the court and with Ms. Broy at Victim Witness Services, seeking the no contact provision to be lifted. If you don't want to argue that for your client, that's fine, but that was the message you were supposed to get. If all parties can get here, I'll hear argument on it.
I think I mean, I don't know if Ms. Smith is there. I know that both Ms. Smith and Mr. Stoddard are both disabled. They have some significant mental issues. Mr. Stoddard, due to the fact that he was hit by a vehicle a number of years ago. And obviously his mother is his legal guardian now as an adult. And Ms. Smith has, I believe, I'm not speaking out of turn here. Things are known to the Stoddards. She suffers from ADHD. She's bipolar and she has PTSD and has also is the type of person that isn't normal neurologically. So I know that she has reached out to the Stoddard family and said, I didn't say these things to the police and nothing happened. And I told the Stoddards, not to speak with her about this. because and this was before a bond was set in place. I spoke with him before he was arraigned, Your Honor. And so now they're having no contact. And I think Ms. Smith wants to undo whatever was done on this case. But that is a function for the executive branch to determine. And I do believe it is in my client's best interest right now not to have contact during the pendency of this case, even if Ms. Smith wants contact, because I want no wrongdoing ascribed to Mr. Stoddard or his family or myself. I understand the rules, the ethical rules, the no contact rules, and the criminal rules very well. And I think at this point, it behooves everybody to keep the no contact in place. And if there's a resolution and the case is dismissed, then Ms. Smith and the Stoddard family can discuss how they want it to proceed in terms of the Smith-Stoddard romantic relationship and the family relationship at the appropriate time. So I appreciate the court setting this up, but that's my position right now, and that has been my strong advice to the Stoddards from the beginning.
Well, we have not called this case, so we are not on the record in this matter. We're treating it like a pretrial conference. The state, Mr. Sheehan is here and he can chime in if he would like, but that is why the court set this. In the face of these multiple contacts, we thought we should give opportunity, and I appreciate your transparency, Mr. Kuipers, and I certainly can appreciate your position. Then we will not hear a motion on this today, and the bond will remain as it is set.
Okay, thank you, Your Honor, and I appreciate you setting it up. Hopefully, Mr. Sheehan or whoever is assigned to the case will be able to handle it, but I did talk to Mickey last night too, so he knows my position and it got the same information I told the court today.
Okay, all right. Well, again, we made the court available, and I think probably this is, based on your comments here, the most appropriate outcome. So,
Okay, thank you, Your Honor.
Mr. Kuipers, you may go, as may the Stoddards and Ms. Smith. And Ms.
Take care.
Roy, I think were you here on this or something else?
Hi, Judge. I was here on this case, and I'm wondering if I can do a breakout room with Laura and possibly Mr. Sheehan, if he's available.
Yeah, Mr. Sheehan is here. I can set that up.
Okay, thank you, Judge.
Okay, so Mr. Sheehan, right, and then I will place them into the breakout room. They should be on the laptop with you.
Okay.
Hopefully this will work.
Okay, thank you.
Mickey, let me know if you got any other information. Nice to see you, Your Honor, and you too, Todd. Take care.
Okay.
Laura, hey, Laura, we're gonna go in a private breakout room to discuss what was just said. So just one moment.
Or hearing me at all?
So watch your screen for an invitation to go into a breakout room. And you will have one on that laptop as well, Mr. Sheehan.
Yes, Judge.
Not
I didn't know if
that laptop, the laptop in there.
Right. I didn't know if Mr. Blumenauer was ready. I didn't want to.
I don't see him back yet, so.
I'll run over there.
Mhm.
Mr. Manny, I'll give you one.
All right, I think I put
I see it.
all of the right people in there.
And that was all off. the record.
Yes. Good morning, officers. Officer Robertson, which matter are you here on?
Hi, I'm actually Officer McConnell.
Oh,
I'm not
that's
sure if I
Officer
can
Robertson.
switch. I am here for the Christian versus Gage, I'm sorry, Michigan versus Christian.
Is it Bulow?
Yes, ma'am.
All right. Are both of you here on Bulow?
Yes.
I don't have that on my docket until 10:30. So I'm gonna turn your cameras off and mute you, or you're welcome to go and come back at 10:30, but I don't have all parties here yet. So wanted to let you know you don't need to stare at the screen for 30 minutes. We'll see you back here in half an hour or so.
Very good. Thank you.
Okay,
ma'am.
thank you.
Yep. And Mr. Bulow, if you can hear me, when your attorney gets here, we'll let you meet with him.
Yes, ma'am.
To those of you waiting on Zoom, I'm just going to ask you to hang tight. We have a proceeding to conduct live, and then the court will be back with you. You are broadcasting live into the court, though. The court is calling the case of the state of Michigan versus William Morales Sanchez, case number 20-60094 FY. We'll wait for Mr. Morales Sanchez to join us.
And good morning, Your Honor. Nick Sheehan, on behalf of the people.
Yes, counsel, your appearances.
Thank you, Kristen.
You are William Morales Sanchez? Good morning, sir. This matter is before the court for a finding on competency. It was my understanding that we were going to be calling witnesses and taking testimony this morning. Is that no longer the case, Mr. Denny?
No, that's no longer the case, Your Honor. I forwarded by email to the court staff and the people, signed stipulation for the court to take the report that was written by the Forensic Center without purposes of having the doctor here.
I did receive that stipulation, but it indicates that the defendant, through his attorney, Kellen Dotson, is stipulating to that. And so I understand Mr. Dotson is no longer with your office.
Correct.
And it was late in the day yesterday, so we appreciate you being here to just clear this up, Mr. Denny.
Sure, no, that's no problem.
And so the defense then is stipulating to the entry of the written report by the Forensic Center for Psychiatry. Mr. Sheehan, any objection?
No, Your Honor, and I also do have a finding in order of competency for Your Honor to check appropriate boxes.
Well, I do have one as well. Thank you.
All right.
Somebody provided it to me also.
I think Mr. Denny or Mr. Becker did do that prior to this morning, so I think that.
All right, and so having reviewed the evaluation authored by the Michigan Center for Forensic Psychology, it appears to this court that the defendant is competent to stand trial and that this case shall continue to the next stage of the criminal process. I do not, let me check. Mr. Denny, is he receiving medication at the jail?
Yes, I believe he is. So my understanding is he's receiving medication.
Yes, and so he's ordered to continue to take that medication to maintain competency. How long do we need before preliminary examination in this matter?
If you remember, we had email exchanges with the court staff, and we ended up landing on June 3rd.
All right, that notice doesn't. Let's look in the file. June 3rd at 10 a.m. and this notice indicates in person.
Yes.
All right. I did get notified this morning that this court is moving back into phase 2 of the Supreme Court Administrative Office's phased reentry plan. We've gone forward and backwards several times, several steps. And so we will be able to be a little bit more flexible when you appear in person for that prelim in June. Hopefully, I'm going to sign this order. Is there anything further in this matter, Mr. Sheehan?
No, Your Honor.
Mr. Denny?
No, Your Honor. Can I wait for a copy of that?
I was just going to ask for someone to come up, but let me put my mask on.
Thank you.
All right, if you would like to approach Mr. Sheehan, I have a signed copy for both you and Mr. Denny.
Thank you.
Thank you. Oh, wait, oh, I'm sorry, I lied. Because I didn't check this on the copies. I don't have a copier up here. Very good. Hand do it with the signature. There you go. Thank you. All right, I believe we're all set in this matter.
Thank you, Your Honor.
You're welcome, Mr. Denny. Are you able to share where Mr. Dotson has gone?
Minnesota.
Really?
Took a job at the head of the county public defender's office in Minneapolis. So he starts there in June. And he's in the process of finding a place to live.
Wow. Wow. The prospect of moving is daunting. Moving across country is even more so. I wish him the best of luck.
You know, we actually, our office has lost 2 now. At the county public defender's office in Minnesota.
Really?
Not a place I expected to get poached, but.
No, I don't. I doubt that that's really on your radar, but interesting. All right. Are you appearing on any other matters this morning, Mr. Denny?
Not this morning.
All right. Thank you for coming on. I appreciate it.
Thank you very much. Good to see you.
All right. Mr. Blumenauer, are we ready to proceed on Mr. Let's see, which. Who are you here on? On Mr. Newton, or do you need another opportunity to speak with Mr. Sheehan?
Well, I'm, you know, if we can, if I could talk to Mr. Sheehan for a sec, I'd appreciate it. My client is a little, well, he's apprehensive of waiving right at the moment, but it's a possibility, you know.
Well, how about I put you in a breakout room and you can have that conversation. Actually, let's see. Conference room 4.
Sounds good. Thank you.
Is still, you're welcome. I'm going to put everybody together.
And by the way, Mr. Dotson's in good company because I believe an attorney, civil attorney, Joe Jamal. I don't know if you know Joe. He's with
That name is familiar, but I don't think I know him.
Stanger over here on 28th and East Paris. He regularly goes to Minnesota. That's where his family's from, or rather, that's where his wife's family's from. So.
What's so interesting in Minnesota? I just.
I'm gonna miss Kellen. I'm gonna miss him.
All right, I am gonna move Mr. Sheehan to you, and you should be able to use the same invitation to the breakout room that you had before.
Understood. Thank you.
Mm-hmm.
If I can find it, where the devil do I put it? Ah, breakout rooms. There it is. Yep.
Good morning, Mr. Anderson.
Good morning, Your Honor.
Do you need a breakout room to speak with Mr. Bulow?
Please.
Happy to oblige. All right, Deputy, there should be an invitation for Mr. Bulow to join his attorney. Good morning, Mr. Lawler. The court sees you. You can stay muted. Your attorney was here earlier today and will be back. I expect him any minute now. Welcome back, Mr. Stevenson.
Thank you, Your Honor.
Would you like a breakout room with your client?
No, thank you. I believe we're prepared to proceed whenever the court's ready.
Well, we are sans one prosecutor, so when Mr. Sheehan rejoins us, we'll be able to proceed.
Absolutely. Thank you.
Thank you. The court is calling the case of the state of Michigan versus McKinley Newton III, case number 21-60111FY. Counsel, your appearances for the record.
Good morning, Your Honor. Making sure you're on behalf of the people.
Michael Blumino, appearing on behalf of the Mr. Newton.
Good morning, gentlemen. This matter is scheduled for a probable cause conference today. Is there an offer being extended by the state, Mr. Sheehan?
Yes, Judge. I did speak with Mr. Blumenauer, I believe earlier this week. I did send one of our pre-exam conference form sheets. I believe I forwarded also to your court or your clerk. You don't have a copy of my one, but the offer extended at this time was as charged with further negotiations in circuit court. After speaking with Mr. Blumenauer, who had spoken with Mr. Newton in a breakout room, I think we're going to leave this case on for the probable cause conference scheduled for next week. I will subpoena witnesses. Mr. Blumenauer indicated that he'd like to speak to Mr. Newton a little bit more about the case. If for whatever reason that Mr. Newton does decide to waive his preliminary examination before next week, Mr. Blumenauer was nice enough to tell me, or is going to tell me and instruct me that I can cancel witnesses. But for now, we're going to leave it on for the preliminary examination with witnesses. Correct me if I'm wrong, Mr. Blumenauer.
No, the entire thing's right.
All right. You are Mr. Newton, McKinley Newton. Sir, will you come up to the lectern, please? It is always a little strange when we have a client here in person and an attorney on the Zoom screen. Sir, this matter is set for a preliminary examination next week, May 20th at 10:30 in the morning. The purpose of that hearing is for the state to prove that there's probable cause to believe that the crime charged is committed and probable cause to believe that you are the individual who committed it. At this time, your attorney is indicating that we're going to leave that on. And so we will see you back here next week, May 20th. Do you have any questions for the court?
No, ma'am.
All right. Anything further on this matter, Mr. Sheehan?
No, Your Honor. Thank you.
All right, Mr. Blumenauer?
Nothing further, Your Honor. Thank you.
All right. You are welcome. Thank you very much, sir. You may go.
Thank you.
All right. The court is calling the case of the state of Michigan versus Michael Leon Lawler Jr., case number 20-60312FY. Counsel, your appearances for the record.
And Brett Stevenson on behalf of Mr. Lawler.
Good morning, gentlemen. This matter is scheduled for a preliminary examination this morning. Mr. Stevenson, how are we proceeding?
Thank you, Your Honor. For the record, last week when we were here for the PCC, I hadn't had contact with Mr. Lawler. The court was kind enough to accommodate us with the breakout room. So we set it for prelim today without witnesses so I could further understand Mr. Lawler's version of what transpired. At this time, we'd respectfully request that this matter be set for preliminary examination at the court's discretion, and we would ask that witnesses be present in person.
Certainly we can do that, Mr. Lawler. You do have the right to preliminary examination in this matter. The purpose of that hearing is for the state to prove that there's probable cause to believe the crime charged was committed and probable cause to believe that you are the individual who committed it. Do we have the register of actions doesn't indicate. Mr. Stevenson, have you spoken with your client regarding waiving the 14-day requirement from arraignment? I would assume so.
Yeah, Michael, you have no objection to having this set for a hearing outside of the 14 days, do you?
You are muted, sir.
I apologize. I did not try to do that. I said I do not have a problem with it.
Thank you, Michael.
All right, I do not have a clerk in here to generate a date at this time, but we will get one generated and notice sent out. Anything further on this matter, Mr. Sheehan?
No, Your Honor.
Mr. Stevens?
No, thank you, Your Honor. Michael, just call me tomorrow if you have some time, okay?
Yes, sir.
Thank you very much, everyone.
All right, thank you.
So I'm done. Court's over.
Yes, you may go.
Okay, thank you.
Which leaves us with just Mr. Bulow. Mr. Anderson, are you there?
I am.
All right. Do you need a breakout room with Mr. Sheehan? I'm sorry, I didn't catch that.
I don't think so. I texted him.
All right.
For an impasse, so I guess we'll go ahead and run it.
Okay. All right. The state is calling the case of, or the court is calling the case of the state of Michigan versus Christian Gage Bulow, case number 21-60084FY. Counsel, your appearances for the record.
Good morning, Your Honor. Mr. Sheehan, on behalf of the people.
Good morning, Your Honor. Michael Anderson on behalf of Mr. Bulow.
All right. This matter is scheduled for preliminary examination this morning. How is your client going to proceed, Mr. Anderson?
Your Honor, at this time, we're going to request or demand the preliminary examination. I'm looking back to see what the offer was.
The court record reflects in exchange for a voluntary plea to count 1, the state would dismiss count 2 and the supplemental information. Is that correct, Mr. Sheehan?
That's correct.
Is that offer still on the table?
Yes, sir.
All right, and you are.
Mr. Bulow, did you want, just to confirm, did you want to waive and preserve that offer or run the preliminary examination?
No, I'd like to run the preliminary examination, sir.
All right, and you are Christian Bulow, correct?
Yes, ma'am.
All right, sir, you do have the right to a preliminary examination. At the preliminary examination, the state must prove that there's probable cause to believe that the crime charged was committed and probable cause to believe you are the individual who committed it. The charges in this matter are count 1, possession of a controlled substance, less than 25 grams, a felony punishable by up to 4 years, and possession of analogs, a controlled substance, a felony punishable by up to 2 years. Mr. Sheehan, is the state prepared to proceed today?
Yes, Your Honor, we are. I believe all the officers are here to the downstairs prepared to testify via Zoom, but Your Honor, rather than be in the courtroom.
I have that this was going to be on Zoom, and so they can testify as they are comfortable. The officers were here. They had signed in at 10 o'clock, and I told them that they could turn off their cameras or come back at 10:30, but nobody else has joined me.
Your Honor, they're downstairs in one of our training rooms, just standing by. So
Okay.
either in the building or via Zoom, whatever you prefer.
Okay. I think for recording purposes, if they are comfortable, we prefer them in the courtroom.
I'll go grab it.
Thank you. All right. Okay, the court's going to take a brief recess so that we can mic the litigants who are here in person. Mr. Anderson, I'm told that you need a breakout room with your client.
Yes, just briefly.
All right, so you should be able to use the same breakout room that you had before, the same invitation, and deputy, you should be able to use the same invitation as well to get Mr. Bulow into the breakout room with his attorney.
Yep, it shows up, so I will click on it.
Mhm.
Judge, if you can hear me, we are going to enter a plea to that offer.
All right, we heard you, but we don't have Mr. Sheehan in here, so give us a couple of minutes. All right, we are back on the record in the matter of the State of Michigan versus Christian Bulow, case number 21-60084FY. We were preparing to run a preliminary examination in this matter, and the court has been informed that a resolution has been reached. Mr. Sheehan, did the offer then change?
Yes, it did, Your Honor. After speaking with Mr. Anderson about some nuances in the law, I've also discussed with detectives and officers. And I made the decision to extend a new offer in this matter upon successful plea and sentence to an amended count of use of fentanyl and an added count or amended count of use of analogs, which are both 1-year misdemeanors. The people will dismiss the possession of fentanyl, which is a 4-year felony, and the possession of analogs, which is a 2-year felony.
And did you discuss that new offer with your client, Mr. Anderson?
I did, Your Honor.
How would he like to proceed today?
He would accept that offer and enter a plea in both of those counts.
All right. Mr. Anderson, did you discuss with your client his right to a trial and the misdemeanor rights in this matter?
I did, Your Honor. I could submit, with Mr. Bulow's permission, I could submit a signed form on his behalf. Do I have permission to sign that we discussed those rights, Mr. Bulow?
Yes, sir.
I will send a signed form to the court, Your Honor.
Thank you. Mr. Bulow, did you hear the offer as read by Mr. Sheehan?
I did, ma'am.
All right. And is it your intention to accept that offer and enter a plea today?
It is.
If you tender a plea and the court accepts it, there will not be a trial of any kind. Do you understand?
I do.
All right. And it is your voluntary choice then to waive your rights to a trial and all the rights that go along with it in order to take advantage of the bargain being extended by the state?
Yes, ma'am.
Did anyone threaten you or make you any promises other than the plea bargain in order to get you to enter a plea?
No, ma'am.
All right, then as to the amended count 1, use of fentanyl, a 1-year misdemeanor, how do you plead?
Guilty.
And as to the amended count 2, use of analogs, how do you plead?
Guilty.
All right, I do need a factual basis established. Counsel, are you stipulating to a factual basis, or Mr. Anderson, would you like to inquire of your client?
I think we can take a factual basis on the original charge. Would you like me to inquire, Your Honor?
Sure.
Let me just verify the address on the complaint. Mr. Bulow, on or about March 22nd of 2021, were you at the address of 3747 29th Street in Kent County, in the city of Kentwood?
I thought it was 3749, but if the extended stay, yes.
Okay. And on that date and time, did you knowingly possess the substance fentanyl?
I didn't know that it was fentanyl. I just thought it was heroin.
Okay. But did you know you knowingly possessed heroin?
Yes, sir.
Did you have a legal right to possess the heroin?
No, sir.
And on that date and time, did you also possess a controlled substance analog? I believe in this case it was Xanax.
Yes, sir.
And did you have the legal right to possess that drug?
That, sir, I'm not sure of the law. I don't know.
Okay. Was it your prescription?
It was not.
Your Honor, I believe Mr. Bulow has given a satisfactory factual basis to be taken for both the use of fentanyl and the use of controlled substance analogs.
All right, I will accept that as a factual basis. Mr. Sheehan, any objection?
No, Your Honor.
All right, sir, the court will accept your guilty plea and find you guilty, but before I sentence you, I do want to know more about this situation and about you. And so I am going to schedule this for a pre-sentence investigation. A report and recommendation will be given to the court and you'll return for sentencing. Are you being held on other charges?
I have a hold in Allegan County, but in Kent County, I don't have any other charges.
Your Honor, he has to resolve a driving while license suspended in Allegan County. He has been in custody since the date of this, or actually not the date of this incident. They weren't able to take him into custody, but I believe it was April 13th that they took him into custody. So with good time, he has almost 40 days credit. And given that these are usage cases that would typically have a minimal jail sentence, I would ask Your Honor to consider a PR bond. I did discuss with Mr. Bulow that Your Honor does usually request PSIs, and that if he, when he gets out, he would have to contact the Kentwood Court and make an appointment and make sure that he appeared for sentencing.
Mr. Sheehan, does the state take a position on a bond reduction?
Your Honor, as always, we'll leave it at the court's discretion. As Mr. Anderson stated, they are felonies that reduced to usages, misdemeanor cases. The concerning part for the people is just that reading his pre-bond report, there are quite a few bench warrants and failure to appears going back to 2006 until present day. That would be the only concerning thing. However, we'll leave it at the court's discretion if Your Honor would like to give a PR bond.
May I briefly respond, Your Honor?
Yes.
I did speak with Mr. Bulow about that exact concern. He stated that he recently had a child. He's seriously working on getting clean, and he does want to receive treatment and help from the court. I think that his history obviously is littered with controlled substance offenses. I think it sounds like he is serious, and given that he's clean and he understands the consequences that if he weren't to report, I would ask Your Honor to still consider allowing him a PR bond. Additionally, he has given me contact information, so I have a phone number and address where I would be able to reach him.
All right, thank you, Mr. Anderson. Mr. Bulow, is there anything that you would like to share with me before I decide if I'm going to reduce your bond?
The main problem that I have since 2014 has been drug abuse. I finally got into Genema House, and as soon as I got to Genema House, I was there for like 2 weeks, and quarantine shut down the state of Michigan. When quarantine shut down the state of Michigan, I tested positive for influenza B and was medically terminated. I never once got back in any treatment. But during that time, I managed to somewhat stay stable. I got a job at the Red Project as the overdose prevention coordinator. The reentry program that I was a part of in jail told me that I was their success program. I was let off probation, felony probation, 2 months early because of my success. My wife is currently incarcerated in Allegan, which is why I was liking a PR bond. So if I have to go to Allegan County, at least then I can have a visit with her, be in contact with her until that's resolved. But just my partner being gone, it just took a stress toll on me. And I had a lapse of judgment. When I was rearrested, note that I did not have any drugs on me. I had been doing my best to get clean for the better part of 3.5 years now, but it's just people, places, or things. Since I've been here for the month, I've diligently been reading my Bible. I even told Mr. Anderson that I would like to be put on probation because I need that accountability. Yes, 2006 was what, 15 years ago, and I want to be 31 tomorrow. There's been a lot of maturity and growth throughout those 15 years. I'm not at risk of running. I just want to resolve my drug addiction. If granted a PR bond or a deduction in my bond, the court's not going to regret it.
Let me ask you this, Mr. Anderson, is there any objection to proceeding to sentence on this matter?
No, Your Honor.
Mr. Sheehan? All right, having heard the bond reduction motion, but thinking it more appropriate an allocution, I think we will proceed to sentencing on this matter, Mr. Bulow. That being the case, then, Mr. Anderson, anything to add?
No, Your Honor. I think Mr. Bulow spoke, said everything, that I would have said, along with and I would just leave it at that, Your Honor.
All right, sir, it is not very many that come in front of me that say that they want probation in any given case. Sentencing has a number of different objectives. First, there is the punitive element, which is the punishment you get for breaking the law. And then second is a restorative element. I'm not hearing that there's any claim for restitution in this matter. But I do see that there is a need for rehabilitation, which is another objective of sentencing. And this court would also like to see you stay clean, and it sounds like you have good motivation to do so. I heard you just had a child. Where is that child?
Well, my son is, he just turned 2 on Cinco de Mayo. But he's at his uncle's in Belding. It's a really good environment for him. We did temporary custody once our life started getting unmanageable so that he was in a safe and well place. And the goal is to get him back into our household. My daughter will be 13 in 3 weeks. She lives out of state. And I just, been estranged from her for the majority of her life. And it's one of the bigger regrets of my life. Having my son on a regular basis has kind of brought to light the importance of, being there for your children. So I've pretty much broken down the FOC handbook, and I've learned how to file motions myself with the help of legal aid. So it's just, I know what I need to do. It's just having the right support to get it done.
Well, and that is one of the great things about probation. If you are not looking at it as a punishment, you are looking at it as a resource. We can provide you the tools and the accountability to stay clean and get it done as you suggest that you want to do. And so I will sentence you to probation in this matter. It will be a term of 14 months. The terms of your probation are as follows. You are not to violate the laws of any city, state, or federal government. You are not to leave the state without the court's permission. You are to make a truthful report monthly or more often to your probation officer as they require. You must notify your probation officer of any change in address or employment status. I want you to attend a 12-step support group as directed and verify that with your probation officer. You are not to possess or consume any alcohol, recreational marijuana, or other drugs unless prescribed by a physician. You are not to misuse prescription drugs or be in the presence of anyone using illegal drugs. You will come here to drop And so you will submit to drug testing and pay that fee. I'd like you to obtain a substance abuse assessment. I think it is going to be helpful. You are to complete or continue counseling as directed by your probation officer. My purposes are never to duplicate, to make you jump through additional hoops. Whatever program you get in is sufficient. Work with my probation department to find what's right for you. If you go back to Jelma House or you do whatever you need to do. Yes, sir.
So is the reporting at 42 Walma?
4740 Walma.
All right.
Yes. You are not to purchase or possess any firearms or ammunition or dangerous weapons. You are to seek or maintain employment and verify that with your probation officer. You are not to drive at any time without a valid license. Do we have a consensus on the number of days? From April 13th to May 13th, that's 30 days, correct?
It was April 14th, ma'am.
Mr. Anderson?
I think if you count today, I think that's still 30 days.
We'll sentence you to 30 days, credit for 30 days served. You are to report to the 62B District Court the next business day after your release, and make arrangements for your probation, meet with your probation officer, and set up a payment plan. You pay fines and costs, and I'll assess at this time. Sir, do you have a job lined up once you're released, or do you know what you're doing in terms of work?
I've got a couple of prospected jobs, like removing lead from paint. It's just getting out and having everything lined up in order to be able to do that job. But I have been networking since coming to jail. There's a couple opportunities. I can always go back to my old job at Preferred Quality in Standale as well.
Fines and costs in this matter total $1,885. As I said, first business day after your release, you can come here to set up your probation, get a copy of your probation order and sign it, and set up a payment plan. I know you have to resolve your matter in Allegan, and so again, first day after your release. Anything further on this matter, Mr. Sheehan?
No, Your Honor, thank you.
Mr. Anderson?
No, Your Honor, thank you.
All right, Mr. Bulow, I wish you the best of luck.
No, thank you.
Thank you, Your Honor.